Welcome to Employment Law This Week. I'm George Whipple. The COVID-19 pandemic ushered in a new age of remote work, and employers are responding by developing new hybrid and remote work models. Epstein, Becker Green's Adam Tomiak and Joel Eisenreich from Deloitte Tax LLP are here to tell us about some of the considerations and possible legal ramifications of remote work.
The overwhelming feedback that we've received from companies is that remote work is here to stay. In fact, during a recent poll that we conducted with over 500 companies, over 79% of organizations indicated that they intend to incorporate remote work as part of their go-forward talent strategy. Employers are focused on taking a number of steps to implement policies and procedures, to implement technology-enabled solutions with a long-term perspective towards operationalizing remote work.
Employers who have embraced hybrid and remote work are continuing to explore new iterations of these arrangements to meet their organizational needs. For some employers, the priority may be further enhancing their employees' experience and encouraging remote work from anywhere. Other employers have been focused on ensuring appropriate controls and structure around remote work so that efficiency and collaboration are not sacrificed in a Zoom-heavy work environment. In addition to expanding options for where employees work, employers are also exploring offering variability in when employees work, allowing shifted or adjusted working hours and days. Allowing employees to work from anywhere they have a Wi-Fi connection may seem like a quick, easy benefit to offer employees, but where employees are physically located still matters significantly in terms of legal risk management. Individual jurisdictions, including at the state and local level, can have entirely different rules for workforce management and can provide employees access to new entitlements for time out of office, access to personnel data, or even influence rates and frequency of pay. Where an employee is located can also impact the enforceability of post-employment restrictive covenants and arbitration agreements. And when employees cross international borders to foreign jurisdictions, there are significant implications with respect to work authorizations and visas, as well as taxes, to ensure work abroad is permissible.
To the extent employees are no longer working in the company's physical office location, they can be potentially working in different states, in different countries, in jurisdictions where the company does not have a prior footprint. And that can give rise to a number of different tax considerations impacting both the employer and the employee. From an employment tax perspective, to the extent the individual is working in a different state or country, that will require the employer to withhold employment taxes in that jurisdiction. To the extent the employer doesn't have a prior footprint in that jurisdiction, the employer might have to register. As it relates to the employee may potentially face double taxation to the extent that a tax credit is not available for those additional taxes. From a corporate perspective, to the extent you have employees working in different jurisdictions, that can create nexus from a state tax situation, requiring the company to pay state tax in jurisdictions in which it otherwise would not have been required to. As it relates to countries abroad, having employees work remotely can create permanent establishment issues as well.
Thanks, Joel and Adam, and thank you very much for watching. We'll see you next time.